So at this time, Mr. Brown, because you did not do what I asked you to do or what I ordered you to do, I'm going to raise your bond.
Challenge subject matter jurisdiction.
That's overruled. Listen, Mr. Brown, I'm raising your bond to $100,000 in each of your cases for not following the court order. Go back with the bailiff. Go back with the bailiff. Go back with the bailiff. You're going to make it worse if you don't.
Yeah, respectfully, this is not a fair trial.
You don't get to say respectfully and then be disrespectful. Go back with the bailiff.
She started, don't make me lay hands on you. Why would you lay hands on me? Because you're not doing it. I'm telling you, now go.
Mr. Braden, you need to go back with the bailiff. There's right now, I've raised your bonds. You have to go with the bailiff.
Not a threat to any officer. You through him, Judge?
Yes, I'm through.
I am not a threat to any officer. Let's go. Why are hands on me?
Yeah.
Why are hands?
I told you I was gonna put hands on you.
Nasir Brown. Are you Nasir Brown? I'm sorry.
We were here before.
You've been here before, but you have to speak up where I can hear you.
Executing beneficiary of the trust in hand.
Of the trust of what?
Of the trust in hand, yeah.
Of the trust in hand? Whose
Yes.
hand? What trust?
Execute.
Did you bring a copy of it?
I wasn't able to get to the copy. I do
Take the glasses off. I need to see your eyes, please.
These are my prescription glasses.
That's okay. So I'm having a hard time understanding you. You need to speak up and speak clearly so that the record can be clear. You were already here and I gave you an opportunity to try to go hire a lawyer for your two cases. Did you get a lawyer hired?
Able to do it.
Who'd you talk to?
Made a few calls to the guy, Rafe. What's his name? Rafe King?
Mm-hmm.
What's his name again?
Who else?
That's the lawyer that I chose.
So if you chose him, you should have gotten him high. I mean, he has the same, there's somebody that answers his phone every week. I understand. I know how it works. I told you to hire someone or visit with at least 3 lawyers.
Made an attempt.
You made an attempt. Okay. Did you go see Mr. Kimler? Did you make an appointment?
Able to do that.
Why not?
I'm not in a position to go back and forth in front of the lawyer that's in this state that I'm not following. This is falling names.
So here's the thing, Mr. Brown, I told you very specific instructions when you were here before that if you did not do what I asked you, then your bond would be raised and you would have to go back to jail, right?
No.
Yes, that's exactly what I say. Because I say you've heard me say it probably 8 times already this morning. So at this time, Mr. Brown, because you did not do what I asked you to do or what I ordered you to do, I'm going to raise your bond.
Challenge subject matter jurisdiction.
That's overruled. Listen, Mr. Brown, I'm raising your bond to $100,000 in each of your cases for not following the court order. Go back with the bailiff. Go back with the bailiff. Go back with the bailiff. You're going to make it worse if you don't.
Yeah, respectfully, this is not a fair trial.
You don't get to say respectfully and then be disrespectful. Go back with the bailiff.
She started, don't make me lay hands on you. Why would you lay hands on me? Because you're not doing it. I'm telling you, now go.
Mr. Braden, you need to go back with the bailiff. There's right now, I've raised your bonds. You have to go with the bailiff.
Not a threat to any officer.
You through him, Judge?
Yes, I'm through.
I am not a threat to any officer.
Let's go.
Why are hands on me?
Yeah.
Why are
I
hands
told you I was gonna put hands on you.
Why are hands being put on? Y'all see this on the camera?
And right there, put your hands on the wall. Okay, put your hands on the wall, but you're not listening. Oh, listen, I don't know that.
Blaine Dunnigan. Good morning, sir. Are you Blaine Dunnigan? And will your client waive the formal reading of the indictment?
It will, Judge.
See, Mr. Dunnigan, in cause number 25, DCCR 0566, you're charged with the 3rd-degree felony offense of driving while intoxicated, 3rd or more, and that's from April 9th of 2023. The indictment alleges you were previously convicted of driving while intoxicated November 3rd of 2016. And after that was final, you were convicted July 6th of 2020. And how do you plead to that charge?
Yeah.
And are those 2 prior convictions true?
Yes, ma'am.
Did you enter your plea of guilty freely and voluntarily?
Yes, sir.
And did you plead guilty because you actually did what they've charged you
Yes,
with?
sir.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Gertz?
Yes, sir.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like that agreement is for a 10-year term in prison, but that would be probated. You'd be on probation for 5 years. You would be ordered to pay a $500 fine and to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenors number 1,
I have no objection, Judge.
it's admitted. Is there any evidence that Mr. Dunnigan's not competent?
None at all, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll just give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's at that desk right there.
Yes, ma'am.
All right, we'll see you back at sentencing.
Thank you, ma'am.
And what about Felicia Freddy? Just go through the motion.
I mean,
I get pleased today and then reset it for sentencing.
yeah. So she's just.
Good morning. Are you Felicia Freddy? Speak up loud
Speak
and
up
clear
a
so
little.
I can hear you and so the court reporter.
Yes, ma'am.
Please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you. You can put your hand down. Will your client waive the formal reading of the motion?
She will, Judge.
Ms. Freddy, in cause number 24, DCCR 1390, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation June 23rd of 2025 for the 3rd-degree felony offense of evading arrest or detention with the use of a vehicle. And that was a 2-year deferred probation. Is that correct?
Yes.
Judge, I think there is an error there. I just realized. I think she was placed on misdemeanor eluding probation, not felony.
I think he may be right, Judge. Let me verify that.
If we got it with this down, is my recollection. Judge.
My notes in the file indicates that it was a lesser included fleeing or attempted to elude back on June the 23rd of 2025.
Is that a class A or B?
Eluding is typically B, isn't it?
I'm not sure, Judge.
If I had a second, Judge, I could.
Here, I'll look at the
Mr.
end.
Smith says B.
Leave papers. A. Of that motion, second. Right. So would the state like to orally amend the motion to revoke?
Yes, Judge. To reflect what was actually pled to the lesser included. Lesser.
Any objection to that?
I don't mind the court I'm amending that motion, Judge. It's probably not what you asked me. I don't object with that.
That's good, thank you. Okay, so let's go back. It looks like then in that motion to revoke now as amended, that you were placed on probation for the lesser offense of eluding arrest or detention, a class A misdemeanor, and that was a 2-year deferred probation. Is that correct?
Yes.
The motion alleges that you violated your probation. Count 1 alleges that you committed the offense. So 2, it's resisting arrest, search, or transport, and a silent abusive call to 911 on November 25th of 2025. And is that true or not true? Count 2 alleges that you failed to dress appropriately and conduct yourself in a courteous and professional manner especially when interacting with court officers, staff, probation, or law enforcement officers. Is that true or not true?
True.
All right, so I'm going to enter pleas of not true to counts 1 and 2. We'll get an updated pre-sentence report and we will set this for a hearing. Mr. Coleman, is this something with regard to witnesses that we would need maybe a little more time?
Just a little more.
Then at 11 o'clock, we'll do it on a separate day.
No.
So stop and talk to probation on your way out here of the courtroom. We'll reset this for a sentencing hearing. Anything that you think is important, obviously for me to know, get with Mr. Gertz, and then we'll have that hearing on that date. Okay? All right, you're free to go. Just put it like that other one, make a note that I can find a date for it. Yes. Not an 11 o'clock, an actual day. There's two up. There was another one, right? Jace Stovall. I do, yes, ma'am. All right, sir, you Jace Stovall?
That's right.
And this is cause number 25 DCCR 1872. Mr. Stovall is charged with violating a protective order. And Mr. Gertz has filed a motion to quash the indictment. I've obviously reviewed that motion. Mr. Coleman has filed a response or a reply to that motion, and we're here today on that. I've done obviously some of my own research as
I
well.
filed a reply to Mr.
A reply to the reply.
Agent.
Oh, just a second. I didn't see that come through.
It's short. It will take you 2 seconds to review it, I would suspect. Hyperbolically, of course.
So 1338 has been repealed.
That's my understanding, Judge.
Yeah,
I think
Judge,
the applicable statute is 13A.203.
I think that's correct. If you actually read the language of my original motion, I say that it used to be this, it's now been changed to this, and they mean exactly the same thing. The reason I point that out, Judge, is that the legislature recently revisited venue on this statute and chose not to add where the complainant resides as one of the options. And so that's why I was pointing out what the old statute said and what the new statute says. So
So the new statute is what?
it reads almost identical. It's
13.
13A.203.
Thank you. Okay. Getting there. Just give me a second. I want to look at everything real quick. The indictment in the style is 25072, but it should be 25071, I believe. Well, I mean, that's not, it's violation of a protective order, correct?
It's
it has to be multiple to be a felony. And that's
Well-
what gets us to 7.2, I believe.
7.2 is repeated violation of certain court orders or conditions. 071 is violation of a protective order.
Right. I think they may have kind of pled it as hybrid, but they're talking about O2.
I would concede and agree that it should be O2, Judge.
Okay, so it says 02. That's correct then. All right. Okay. So with regard then to the new 13A 203, this is not a protective order,
It is a protective order,
but
Judge.
the indictment alleges violating a condition of a bond.
I will again concede error on the state's part, and that could be remedied, as I put in my reply, simply by amending the indictment.
Well, I think that probably should have been done because I can't.
I didn't want to amend it until I got the court's ruling on the other issue, the issue of venue.
But that matters. So, okay, so let's do it this way. If it's a protective order specifically, then 13A 203 appears to be specifically on point. So what's the state's position with regard to that? Because it's, I mean, it says specifically what the venue is.
Well, my understanding of 13A.203 is that either it can be prosecuted where the protective order was issued or where the offense, quote unquote, was committed. Certainly, we're not seeking to prosecute it in Travis County where it was issued. The fallback would be where the offense is committed. And since statute is silent in the regard as to whether or not it can be venues proper where the complainant resides, I cited cases that I thought were instructive for the court, Your Honor. In other words, an issue here is the offending communication that was sent, electronic communication allegedly sent by this defendant that violated the protective order. And I think the cases that speak to either obscene or harassing communication that we've cited in my reply, it speaks to venue. In fact, the 14th Court of Houston that cites a Court of Criminal Appeals opinion, it specifically says with regard to an obscene communication, the venue is proper where the applicant or the victim resides. And as it relates to an obscene telephone communication, that's in the in appellate court out of Austin, 1991, that's cited in my reply. It says with regard to that telephone communication, that venue is proper where the victim resides as well. So again, in construing 13A.203, I think those instances are they're instructed for the court to interpret that statute in the absence of more specific language that could have been or should have been provided by the legislature. And I'll just end with this, Judge. To rule otherwise would render, in my opinion, an absurd result in that a victim would have to travel to wherever this defendant may have made the offending communication, be it on a laptop somewhere in another part of the state or maybe even outside of the state, Judge. So I just think that in this day and age of cell phones and mobile digital devices, that that it's more appropriate for the venue to reside where the defendant received the communication.
Mr. Gertz?
Judge, multiple things that Mr. Coleman said I think are incorrect. First and foremost, the case that he's citing is from 1993. It is pre-social media. It's almost pre-cell phones. The case that he cites too, if you actually read the facts of the case, the person was found guilty of a variety of different harassing communications.
Let's go to what I've looked up and what I've found, which, so I tend to agree. I mean, the Article 13A 203 does not say that it's where the defendant is. It says where the offense is committed.
Right.
And so the research to me is around offense being committed, what that means, not where he is, where she is. It doesn't say either of those things. So I don't think there's an automatic argument that it has to be where he is. There is Solis v. State, which is a 2003 case, specifically says venues proper if there's substantial contacts with the prosecuting county that has some relationship either to the defendant, his conduct, his victim, or the fruits of his crime. There's many cases that also say the same thing. There is that this is actually a Torres case. The one that I was reading from is a 2023 case that cites that Solis case from 2003. And so I think the same result that in these types of cases, because of electronic communication, to have to say, we don't know for certain and can't know for certain where either of them were when they were on their phone or whatever they were on doing, either sending or receiving. And so I don't think it should be limited. I think it is a jury question.
May I be heard on that though, Judge?
Sure.
The default position, and the code gives you a default position. The default position is if it cannot be readily determined by the facts, then it goes back to the three other options, which are where he was arrested, which was Travis County, where he lives, which is Travis County. I mean, Mr. Coleman used the word gravamen of the gravamen of the venue statute is about him, not about the complainant. And
But if
you
it
see
can't be determined from the facts, I'm not doing, that's a jury question, is to determine the facts. I don't think that me determining that is necessarily, I think that would put me in a position where I would put myself in the position of the jury in something that's not necessarily as clear as some indictments where a quash would be potentially granted.
May then I be heard just on one other issue?
Yes, sir.
Mr. Coleman raised. So he said that would render an absurd result if we follow the venue statute narrowly. I would suggest to you that it actually renders an absurd result if we follow it the way the state is proposing. Here's why. What it would allow any complainant to do is go to a really favorable county where the police like that person and the judge likes that person and whatever, and then open their Facebook and say, oh, man, I read it in Jasper County and everybody likes me in Jasper County. Let's bring him who's never been to Jasper County.
Well, is that
here.
the allegation about the complaining witness in this case? Did she come here and do that?
I think
Is
she
that what the
moved
allegation?
home to her family's house, but he's never lived here. He's not been a resident here.
But she has that tie here. She didn't just show up.
I understand, but if he's talking about it rendering an absurd result, and I'm saying it's the exact opposite. The venue statute is about whether he has to be hailed in front of a jury for which he has not made his own sufficient ties. It's not about the complainant's ties.
Except that it is sometimes. Specifically,
statute.
no, but the Court of Criminal Appeals has found now several times, Court of Appeals cases and Court of Criminal Appeals cases, that venue is proper in a multitude of places. And so based on that, I think this one is not something that is as black and white as I think you're making it sound, or your perception is. I think that it would create the potential for someone to be able to say, I wasn't there when I said, I mean, everything is, so the movement of everyone with computers and phones, I don't think it should be restricted in this case based on what I know and not what I know about the case, what the indictment alleges with regard to the communications being received by the complaining witness in Jefferson County. And that the case law specifically says that venue could be appropriate in a county where the victim is, where the fruits of the crime were, or where the conduct affected someone in that jurisdiction. So based on that, I'm going to deny the motion to quash. We'll reset the case for an announcement. Go ahead.
I'll get the indictment amended.
Okay,
To reflect protective order versus bond.
that's fine. We won't have any objection to that.
Okay.
Judge, as it should be obvious from all the filings, my client lives in Austin, and so what I'd ask, I don't anticipate there's going to be any offer from Mr. Coleman that my client's going to accept. I don't know if you want to do one announcement and then we can put it on the trial docket at that point.
Yeah, I mean, unless y'all have already negotiated and received everything and gotten an offer, I'm just going to do a normal reset, and you can reject any offer at that time. If there's a rejection, then we'll get it set for trial after that.
Okay.
All right.
Thanks, Judge.
Pretty good.
Thanks, Judge.
In this courtroom session, several dramatic and important legal moments unfolded. Starting with a tense confrontation between judge and defendant Mr. Brown, The hearing quickly escalated when Mr. Brown repeatedly refused to follow the judge's instructions. Despite multiple warnings, he continued challenging the court's authority and refused to cooperate with the bailiff. As a result, the judge raised his bond to $100,000 in each of his cases and ordered him back into custody. The exchange became heated, with Mr. Brown claiming he was being treated unfairly, while the judge insisted he was simply enforcing courtroom rules and orders. Next, the court heard the case of Dwayne Dunnigan, who pleaded guilty to a third offense DWI charge. He confirmed that his plea was voluntary and acknowledged his prior convictions. The plea agreement called for a 10-year prison sentence that would be probated, meaning he would serve 5 years on probation instead of immediate incarceration, along with a fine and standard probation conditions. The judge accepted the plea and scheduled a future sentencing hearing after a pre-sentence investigation. Another case involved Felicia Freddy and a motion to revoke her probation. During the hearing, attorneys discovered an error in the original paperwork regarding the offense she had been convicted of. After correcting the record, the court entered not guilty pleas to the alleged probation violations and set the matter for a future hearing. The final major discussion centered on a legal dispute involving venue, or where a criminal case should be tried. Defense attorneys argued that the case belonged in Travis County, while prosecutors maintained that Jefferson County was the proper location because the alleged victim received the communication there. After reviewing the law and relevant court decisions, the judge sided with the prosecution and denied the defense motion to dismiss the case, allowing it to move forward. Overall, the hearing showcased everything from courtroom discipline and plea agreements to complex legal arguments over jurisdiction and venue, highlighting the wide range of issues judges handle in a single day.